I'm going to talk today about actual bodily harm, ABH. Now, ABH is defined in legislation. The legislation is the Offences Against the Person Act, 1861, Section 47. Actual bodily harm was extended in 1998 under the Crime and Disorder Act, Section 29, to make ABH, that is racially or religiously aggravated, more serious. So an offence under Section 29 of racially or religiously aggravated ABH, that carries a higher maximum sentence. The maximum sentence for religiously or racially aggravated ABH is 7 years custody. The maximum sentence that a Crown Court can impose for ABH under Section 47, the Offences Against the Person Act 1861, is 5 years custody. And the maximum sentence that a Magistrates Court can impose for a single offence of actual bodily harm under the Offences Against the Person Act 1861, Section 47, the maximum sentence for that magistrates can impose is 6 months imprisonment. There is an exception, and it's this. If an individual is convicted by the magistrates of 2 or more either way offences, the maximum sentence that the magistrates courts can impose under those conditions is 12 months custody. So actual bodily harm falls midway within the law concerning assault. At the bottom of the scale is common assault, and I've previously produced a video about common assault. The maximum sentence for common assault is 6 months imprisonment, and common assault on its own can only be heard in the Magistrates Court. Actual bodily harm is next. Actual bodily harm, ABH, is an either way offence. This means that it can be heard at either the Magistrates Court or at the Crown Court. The maximum sentence in the Magistrates for a single offence, 6 months. The maximum sentence for ABH at the Crown Court, 5 years. The Sentencing Guidelines Council sets down the range of sentences that may be appropriate for ABH so that there is consistency nationwide in the sentencing of individuals who have been convicted of actual bodily harm. Above actual bodily harm, you move into grievous bodily harm. So ABH is the midway point. It's a regular case that appears in the court. These offences regularly appear in the courts. They can include elements of domestic violence. They can frequently include, for example, punch-ups in the street. Frequently, actual bodily harm is the offence that is charged. Now, what constitutes actual bodily harm? Well, there is a case called Donovan, and Donovan says that an injury must be more than transient or trifling. So if the injury is transient or trifling, it may be appropriate for it to be charged as common assault. Remember, the maximum sentence for common assault is 6 months imprisonment, so it would have to be something that was more serious than an offence that justified 6 months custody. So examples might be bruising, example might be loss of a tooth, example might be cuts. The Crown Prosecution Service guidelines and the Sentencing Guidelines Council set down examples of what might be appropriate sentencing for particular types of actual bodily harm, but it falls midway between the transient and the trifling, which is covered under Donovan by common assault, and the more serious grievous bodily harm, which as the name implies has to be grievous, at the top end of the scale. So actual bodily harm comes midway. It's an either way offence. Now, there are perceived advantages and disadvantages of ABH being heard in the Magistrates Court, and advantages and disadvantages of being tried at the Crown Court. And those differences, those advantages and disadvantages, need to be considered at mode of trial. Briefly, mode of trial is this. For an either way offence, the first appearance at the Magistrates Court, if a guilty plea hasn't been entered, so if either a not guilty plea is entered or no indication is given, the procedure is that the Crown Prosecution Service will say where they, the CPS, consider the matter should be heard. The defence then make representations where they consider the matter should be heard, and both the CPS and the defence may refer to the CPS guidelines, to previous legislation, previous case law, and of course to the Sentencing Guidelines Council. The magistrates or the district judge will then consider, and it may be at that point that the magistrates decline jurisdiction. They consider that the case is too serious to be heard at the Magistrates Court, and they determine that the matter will go to the Crown Court. However, it may be that the magistrates or the district judge concludes that the matter is suitable for being dealt with in the Magistrates Court. In that scenario, it is then up to the defendant to determine where they want the case to be heard, and there are perceived advantages and disadvantages of being heard in the Magistrates Court and being heard in the Crown Court. Very briefly, in the Magistrates Court, trials tend to be quicker, they tend to be cheaper, they tend to be less formal. However, the individual's guilt is determined normally by a bench of 3 lay magistrates or by a district judge sitting alone. At the Crown Court, the matter of whether an individual is guilty of the offence or not is determined by a jury, 12 lay people. They determine whether or not the individual is guilty or not guilty of the offence alleged, and there are perceived advantages of being heard in the Crown Court. It is thought that magistrates are more likely to convict and jurors are more likely to acquit. It's not always the case, but that is a common perception, and therefore an individual needs to determine whether or not they wish their matter to be heard at the Magistrates Court or at the Crown Court. So to recap, actual bodily harm, it's defined under the Offences Against the Person Act 1861 section 47. The maximum sentence is 5 years custody in the Crown Court. The maximum sentence for a single offence in the Magistrates Court is 6 months custody. The maximum sentence for racially or religiously aggravated actual bodily harm is 7 years custody. So that's actual bodily harm. It falls midway in the offence spectrum, the assault offence spectrum. Below it, you have common assault. Above it, you have grievous bodily harm.